afternoon to everyone and welcome to the sixth webinar conducted by the Outspoken Narrative. First of all, hope all of you are safe and sound. We are going through very hard times right now. Let's all pray for those, for the victims and the family of all those people, all those who have been in the landslide and the plane crash that has happened yesterday in Kerala. And through all the patients or everyone who is going through a very hard time in this world. So yeah, please stay safe and follow all the protocols and rules. So today our class is on the topic beginner's dilemma: to litigate or not, and where. Being a law student, I very well know this is a question that's there in every student's mind. And we are so lucky today to have with us Basant sir to talk to us about this topic and interact with us and to clear our doubts. So without further ado, I hand it over to you, sir. Please start.
Very good evening to all of you. Thank you very much for the opportunity. Am I audible clearly?
Yes, sir. Yes, sir. Yeah.
Okay. Thank you very much. I'm really pleased that I have this opportunity. I know webinars are becoming a real terror for most people now. See, there's so many webinars and for so many such sessions that people have started thinking how to avoid the webinars. You know, very interesting. Friend of mine said, I'm going to attend a webinar. And I said, oh, what? And he said, how to avoid webinars? I'm going to attend a webinar on. Now, that appears to be the situation now. It's a little difficult. As Niranjana rightly told you, times are difficult. It's very depressing. Your state of mind is not very good. And in spite of that, I find a number of people have joined today for this. And that perhaps tells me that how the young people, young lawyers and lawyers to be, are looking at their prospects in the profession. What do I do? I try to avoid webinars these days. I'm sorry for saying that, but then Niranjana was very, very persuasive. She wanted me to be part of this, and then I thought this topic which I would like to speak to you on is something which I think should be of use, of worry, concern for you, and therefore I'll just try to say it's not a talk, it's not a speech, you know, just like to share my views on that to you, because I'll tell you why. About 5 decades back, in 1970-73, I was a law student, and as I was completing my course, you know, as we are approaching the finishing line of your law studies, you always have a problem. You know, you're not sure what you should do or how you should do, how you should, there is a lot of trepidation at that point of time. And, you know, at my time, all that you could do was to litigate. Now, very frankly, a law student had to litigate. You know, at that time, the law course was not as attractive. And in later vein, they used to say, most of the girls who were in our class, in our law classes, were waiting to enter the marriage market. Quite a lot of boys had applied for so many things, and they were trying to find out if they won't get anything, they would think of joining the bar and doing litigation. But your situation has changed considerably. There's a lot of openings for you. Even after you do the law, you have lots and lots of opportunities for you. Most of the companies are today having a law section, law division. Lots and lots of opportunities for you. The court is not the only option for you, and therefore a lot of young minds are now thinking whether to jump into the fray or not. You know, shall I take the dip or this is a problem that you have. I can understand that. Well, what I thought was nothing is bad. You know, you go for corporate work, it's good. You go for some company, a legal advisor, you go. A lot of banks are having openings for law students, you go. And I'm not on that at all. The choice is basically yours, what you want to do. I just wanted to tell you how challenging it is to take to litigation. That's what I want. And how much this country, the system needs active, young, vibrant, idealistic people to join the bar. That is what I wanted to. That's why I thought I shall make use of this opportunity. I'm not for a moment saying that any other opening available is bad. Not at all. When you take a decision, I want you to think of all the options that are available for you. And then, I think, when I joined the law, I know I was certainly wanting to do a litigation, because I told you at that time the options were in many. But then even today, I would think, my son is a lawyer. When he wanted, just the new generation law schools. Immediately after you complete your law, you are taken in by a big law firm, and then you do not litigation precisely. You do desk work for your shall I call them the employer, and then. So what do you do really? This is a problem. You see, very assured income on one side, very lot of uncertainties on the other. So all these put together, the young lawyer, the young law student coming out of the portals of the law college is a little worried today as to what he should do. Now, it is here that I wanted to be of assistance to you, if possible, on making that choice, or giving you strength or courage or confidence to take to a career as a litigating lawyer. That is my first preference is for that. Any intern that comes, try to go for litigation. It offers thrills and challenges which are very peculiar, which I think young minds will enjoy. That's what Before I take you to that, I think broadly, very, very broadly, I would think to join the profession of law, which I mean by litigation, well, rather restricted perception of mine. To be a member of the bar and to do litigation is what I'm speaking to you about. You must have the pride of belonging to a profession. You must have the pride of belonging to what they call a learned profession, as the career in law is usually called. I want you to have pride you to be enamored by the possibility of being the member of the noble profession of law. I want you to realize that here is a profession which is called a gentleman's profession. Once upon a time, it was called the pastime of the nobility, but today I would call it a gentleman's profession. Gentleman means, young ladies need not get disappointed with me. Gentleman means or gentle person. That is all. Not it's a man's prerogative. That is one thing which also I'll take you to later on when I come to that. So being a professional is a very, very, very proud situation for a young mind. Part of a profession. Now, what is the difference between a profession and a career? I want you all to think about that. What is the difference between a profession and a career, as we usually? Every profession today is a career too. I don't think the professionals who join the bar are not looking at it as a career. Not as a career. It is a career also. But I would, in my own way, try to call it something like a career plus. It's a career plus something. What is that? What is that plus? We all want to be lawyers and then earn a livelihood by our hard work. Yes, you have to. But a profession of law is not merely a career. It's something more. Profession is something more than a mere career. And that is where I would think young minds who are attracted to the profession should correctly identify this distinction between a mere career and a profession. And according to me, the profession is a career plus. It's something more than a career. It's a career plus. So what is the career plus? I would think that is the duty of the lettered to the unlettered. It's the duty of the expert to the non-expert. The duty of the learned to the one who's not learned in law. And therefore, it's basically, it has all the ingredients of a career, but it has the dimension of service added to it to make this profession. Or then only this becomes a profession. Do you have that fascination to be a member of the profession and not a mere careerist? Do you want to take up something which will be of service to people who are in need? Well, this I think is very important. Very important. You know, others who join the profession just as a career will later on be disappointed, I'm certain. You will make much more better living by going to other careers than this. The dimension of service is what I want young people making a difficult choice to be conscious of when you come to you're taking to the profession, the noble profession, the learned profession of law. It's everywhere. You know, it's all over the world. The legal profession has always been called the noblest of all professions. And therefore, you understand that when you speak to the nobility of the profession, your yearning to be a professional and not a mere careerist, this is very important when you make that subtle choice between a litigating lawyer and a person qualified in law taking up other appointments, other careers, other avocations. Well, I've always repeated this. I don't know, some of you may have heard me repeat this in some other webinars and all that. But and in my personal view also, the Indian legal system has a peculiar challenge before. It's better we all understand that, no, because I always think it's a pride to belong to the Indian legal profession in this context of history. Today's context of history, it's a long span. No, I keep repeating this. You must all have known that the Indian freedoms movement, the War of Independence, the independence movement, was very, very peculiar. Well, till then the world did not know that an imperial power could be thrown off your yoke by the powerful weapon of non-violence and morality. We have heard of a lot of freedom struggles where you take to arms and fight against the oppressor regime. But the Indian system, led by the half-naked fakir, thought that here are new weapons at our hand, the power of morality, the weapon of nonviolence. These were used to make a suppressed people liberated. Liberty came to them through a wonderful, unique struggle that took place, which was unknown to human history, unknown to civilization till then. It was new lesson for the whole world. The power of morality that you had could win over all oppressors, all oppressive regimes. That is what India showed to the world. Now, when we became independent, yes, political liberty was won in 1947. And then came the question, what can be the type of governance we have? Well, so many alternatives were there. Indian Constitution is an outstanding example of synthesis of various points of view. And you will find India is always called the rich country of very poor people, right? You know that jargon. We are a rich country of poor people. So when we attained independence, we thought, how do we manage our governance? What do we do? What is the policy? What is the arrangement under which it can be done? We had very, very wonderful options from all over the world. The yellow option from the north said, capture all the wealth, distribute it among people, and so that the trammel upon rights, individual rights, you can achieve advancement. But the founding fathers of this country thought that was not the option available for us. They very wisely decided that we will change in accordance with law. We will attain justice by law, justice through law. Well, this is the great experiment that is going on the Indian soil today. Think of 1947, the Indian people were below every conceivable line. Take the literacy line, like the poverty line, take the industrial line. Everywhere we were below the line. But still we thought that India will attain justice for the people, not by any violence, but by orderly transformation in accordance with law. Justice in accordance with law was the mantra that the Constitution of India declared to the world. Well, end of War I for independence started, beginning of War II for independence. What independence? That is economic independence, political independence, social independence, liberty of all the has a lot of dimensions, not only freedom from the alien ruler. And therefore, we thought that we will attain true independence, true liberty, true justice through the methodology of law. And so what happened was in 1950, when the Constitution was, we the people gave unto ourselves the Constitution, we decided we will not capture the wealth and distribute it, but the wealth of rights will be distributed. Well, that's a great Indian experiment. I'm sure the history of civilization will always remember this great experiment that was taking place in India, where transformation in accordance with law, change in accordance with law, justice in accordance with law. And so the very poor Indian citizen when the Constitution was adopted, he found he did not have the wealth which was stored in the storehouses of the temples, the mosques, the churches, and the moneyed people, but his pocket was also full. And what was it full of? It had equal rights. We the people of India, did not have equal wealth, but we had the equal wealth of rights. Equality was the guarantee which the Constitution said, and all the people in India found that we have a lot of wealth in our pockets. The poorest of the poor knew that he had as much rights as the mightiest of the mightiest. And therefore we find what happened was, how does he enjoy these rights? In what manner does he enjoy these rights? Now, in order to make this experiment meaningful to him, he wanted, the system wanted the ordinary citizen to feel that he is also wealthy, he is also powerful. Now, knowledge of laws was very important in this. An awareness of the rights was very important in this. It is not enough if you have all the rights in your pocket, you should know how to exercise those rights. How to translate those rights into tangible reality was a problem which we the people of India faced when we became independent. More so for the marginalized, for the less fortunate, the powerless. They had rights, but they did not know what to do with those rights. That is where Law India plays a very, very important role. In order to translate this conferment of rights on individuals, we needed a legal army. Can I call it the judicial army of India, which can make this conferment of rights meaningful to them. So change in accordance with law has a great dimension so far as the legal profession is concerned. It is for the legal professional to make the conferment of these rights real, meaningful for the ordinary citizen. That is the challenge before the Indian legal profession. And when you are thinking to join the bar or not, I want you to always remember that it's not going to be a bed of roses for you. It's going to be a very, very arduous struggle on behalf of the people of India. In order to make rights available to them, I want people with that persuasion, with that idealist persuasion to join the bar. Because there's a great disadvantage of living long like me. If you start living long, what happens is, you become part of the status quo. But an influx of large amount of idealist young men and women into the legal profession, I'm sure will bring in the transformation and will impress upon the law army of India the real nature of the challenges before it. And therefore, two things are very important for me. One, you understand that you're going to belong to a profession which is not merely career, it's career plus service. Second thing I want to know, the peculiar demands on the Indian legal system and the Indian legal profession today, that you have the burden to make conferment of rights under the Constitution meaningful to the people of India. For whom the bell tolls is a big question. If the bells do not toll for the underprivileged, marginalized, less fortunate citizens of India, there is no point in our having accepted the Constitution. And that is where the new legal professionals must rise to the level and be able to take up the challenge of translating the constitutional promises to tangible realities for ordinary men and women. That, I believe, is it's an inspiration which those thinking of joining the legal profession must certainly have. Well, I would also like to tell you, now, I find there are some young people who join the bar thinking, looking at Mr. So-and-so who's earning in crores every day, Mr. So-and-so who's earning in millions every day. Well, that's a very, very, very small way of looking at things. You can go to any other profession and earn as much money. If money is the criteria, I don't think you should waste your time at the bar at all. It's not worth it. You have to wait for too long a period to make that money, and there are so many ifs and buts in it. If money is your criteria, please, and I won't want any young man to be attracted to the legal profession. Money will come to you, I have no doubt. All sincere, dedicated, conscientious, capable young men and women have made it in this profession, I have no doubt. And therefore, do not worry about that. It's not the financial success, if it is a criteria. I'm sure many of us will get disappointed later on in life for having chosen this profession. I have no doubt. So let that also be away from it. Now, another dimension that I want to know is, I'm sure at this age you must all be inspired to be in a profession which is socially relevant, to be in a profession where people will look upon you as a friend in need. You know, there are two ways of looking at the lawyer's services. I'd been to the United States once upon a time, and then we were part of a lawyer delegation. And I mean, we were some lawyers also, and then they said, there are 4 lawyers and 2 gentlemen in this delegation, you know, because your attitude to the lawyer is very, very negative. You know, even our country, people say lawyers are liars and this and that, you know. But in our country, at least for the present now, I would like to believe that the legal profession is looked upon as a friend in need. A client remembers you as a man who has come to his rescue when he was in trouble. Elsewhere in some of the jurisprudence, some of the systems, they think, here is a man who exploited my misery and aggrandized himself. No, well, if you find pleasure in being a friend in need for people who are really in need, I think this is a profession which will give you a lot of mental satisfaction. So always remember, when you try to make a choice to litigate or not, please do not think only in terms of financial returns, position in society, but think of the other dimension of it, which according to you must be more important at your age, that you being able to help the needy, being a friend in need for many. Now that would be a very important criteria. And I think I want people with that persuasion to join the bar, not the other type. Not the other type at all. See, a life in this profession would be meaningful, challenging, satisfying, rewarding for you only if you have that state of mind where you look at the opportunity to do service to the people who require that service. In the bargain, I'm not for a moment saying that monies are not important. It is important, and it's my conviction that for a person who works hard in this profession, the lady luck has never been unkind to him. The finances have never been unkind to him. But the question is, what do you think is more important? Now I say all this, I know. See, I also had that, I'm talking about 50 years back, but all of you must be having a lot of doubts about joining the legal profession. I'll just try to advert to some of them. And if that is worrying you, please think of them. You know, one is, oh, I am a first generation lawyer. There has been no one in the family who has been a lawyer. I have no godfathers at all. And therefore, I do not know how I can. This profession is one where your father, your uncle, your father-in-law, somebody must be there in the profession, and then only you are there. Believe me, it is not so. Well, those people may find it slightly a slight edge over the others at the initial stage. But take it from me that a godfather is not actually necessary. If you have the will to succeed, if you have the right motivations, if you have sincerity and dedication as you want, and if you have good competence also, let me assure every one of you that it is not necessary to have a godfather in this profession. Godfathers come up. This is a profession where quite a number of seniors encourage competent young juniors. Quite a number. I belong to it. I'm the first generation lawyer in my family. And I always think how my senior had encouraged me, had prompted me, had led me correctly to reach wherever I have reached. So to think that without a godfather I can't do litigation is incorrect. Let me be very plain on that. Don't be deterred by the thought that I have no godfather in this profession and therefore I may not succeed. Yes, those who have godfathers, they have seen. They are who are second generation lawyers, third generation lawyers. They know what the life of a lawyer is. To that extent, they may have a slight edge. But my point is, it's not essential. It is not indispensable. Even without a godfather, a first generation lawyer can succeed. Ample opportunities to succeed. Now, next is, I would think, when I look back in my life, I find many of the bright lawyers who I thought, gentlemen who I thought would make great lawyers have not become lawyers because of financial constraints. It is true. The law, when I joined the bar, the understanding was first 10 years you continue to be a student. 10 years, mind you, 10 years. I'm talking about the early 70s. Now, any average lawyer had to be with the senior at least for 6 to 10 years in order to have the ability to be a good lawyer himself. Well, and we were always told that treat this as an extension of your study. 3 years law in law college, at least 5 years at the bar. That was. And during this period, learning was more important than the returns you got. Well, good seniors always encourage juniors and ensured that the world was kept away from the doors. That is, you had sufficient money to survive on your own, survive and be on your own legs. And I would hope that you find a senior who will certainly be impressed by your hard work and who will make sure, not that you will have enough and adequate money for all the luxuries, not that you will have enough money as your one who joins the corporate world would have, but still you will be the wool will be kept away from the doors and it will be there. I wish, it's my fond hope. Now, if chartered accountants can insist on a law that the senior must pay a certain amount to the apprentice, which will keep him alive, it will keep him afloat, I'm sure the seniors or the bar councils must have an obligation to ensure that good people are not running away from the bar because they are not able to meet the financial requirements. But I'll tell you one more thing. It's all initial teething trouble, which now from 10 years that was there before me, 6 years only. Most of the young men take up work on their own and start doing work by the time they complete 2 or 3 years. And I'd like to repeat to you that I have not seen, it's very frankly, it's an experience over the 50 years, I would tell you. I have not seen a young, competent man with dedication and application not being able to make both ends meet in this profession. Well, I told you, when I look back, I find some of my friends who had family commitments. The family was looking up to them to complete their education, and from the next day onwards, depending upon them. These days, those problems are very little. During my days, every family had 5 or 6 children, and the eldest are always the responsibility to bring up the others. Now, every family has 1 child or half a child only, and therefore, even that problem is not very much there, but still, some places it should still be there. But those who do not have such pressing commitments, I would like you to be patient, wait, and work for yourself and see for yourself the returns that are going to come to you. So do not be unduly worried about the financial part. The initial period of vegetation. There is a period of vegetation. However, you may have scored the first rank in college. I remember when I scored the first rank in my small university, and then when I went to the bar, they pulled my legs by saying, So far, nobody who has done ranked first in the university had ever done well in the profession. This profession is not for the bookish bookworms like you, like that. Well, I would think that any young man who has the requisite amount of competence, the required amount of dedication, commitment, and sacrifice will certainly be able to make both ends meet in this profession. This is my hope and this is my assurance to you. Please don't worry about that. Money will come by itself and be able to, unless you have a very pressing commitment which is staring at you from the first day onwards in the profession. Right. Well, there is another doubt. There are so many ifs and buts. In the legal profession, you join as a clerk, you are bound to get your annual increments and your salary will go up. But when you join as a lawyer, every day it's a challenge. And therefore, every day it's a challenge for survival. And survival of the fittest is the mantra in the profession also. You have to be struggling every time to keep yourself in the front, keep yourself in the profession. And therefore, there are so many ifs and buts. Your success may depend on, your outstanding success may depend upon so many things. And as they call, you have to be lucky to be in the profession. But I will tell you one thing. Yes, in any walk of life, luck plays a part. And so in this particular, the stream of career or profession also. But believe me that the ifs and the buts in the profession are not as vital to deter you from joining the profession. Be very sure that in spite of all these ifs and buts, I repeat, a conscientious, competent, dedicated, hardworking professional will certainly be able to survive in this profession. Yeah, some of my friends, the lawyers that I've said, it's a lot of wasting of time in this profession. Lot of wasting. I know a friend of mine who left the profession saying that I can't tolerate this wasting of time in the profession. You go to the court and be there at 11 o'clock and sit there up to 5 o'clock, your matter is not taken up. The whole day is lost. Right? Like that, it sometimes happens that the young lawyers, I'm sure the young lawyers would feel it more than the students who are there. So sometimes you feel frustrated that, see, I'm in the Supreme Court now. The number of man hours, woman hours wasted in the corridors of the Supreme Court are colossal. We are not good managers. Management of time is one of the great problems of the Indian judiciary. We don't see, for example, we ask a witness to come at 11 o'clock and not leave thereafter until ordained by the court. The poor man comes at 11 o'clock, waits, and then ultimately he goes. Well, I'm sure better principles of management will enter the courtrooms and these will come. Though disappointing to a certain extent as it is today, I don't think that can even that can be a reason for you not to opt for the bar. All right, and therefore I must plead guilty that there is no good management techniques introduced into the functioning of courts even now. I always think, what is the harm in giving a particular time for a case and asking them to come so that people need come to only at that time and do it, or subject to some margin here and there. But why should you get the whole crowd of people from morning 11 o'clock to evening 5 o'clock and waste everybody's time? And therefore, some of the young lawyers feel this very disgusting, and they say, "Oh, I can't be part of this system where your time is wasted like anything." Well, now there is a general impression that the competence in language and rhetorics is very important. You have to be like a great public speaker in order to make a big lawyer. This is another thing. Some of them say, I studied in a vernacular medium school. I don't have that much command over the language, and therefore I'm always worried whether I'll be able to make it. When the people who do not have good pronunciation, good diction, good accent, I find it a great disadvantage. Well, believe me, I want to tell you, I studied in a Malayalam medium school. It's a very, very, very ordinary school. Now, I don't think that has stood in my way of achieving greatness in the profession. Now, with or without that, I don't think I could have been anything more than what I now am. And therefore, young lawyers should understand that ability to communicate is very important. It's very important. But what is most important is not the flowery language, but the ability to convey your ideas in a very functional manner. You don't have to quote Milton and Shakespeare when you start an argument and close it with somebody else's quote. That is not required. Well, in fact, I remember when I became a judge, I've been wondering how much of my time has been wasted looking for a good opening sentence and a good closing sentence. It's all foolish according to me. A good judge is not going to look at your rhetorics of your competence in language. A good judge is going to look at you for your ability to analyze, ability to innovate, ability to forge good arguments on the basis of the materials that you have. These are the things that matter, not your language. I remember I've seen a number of young lawyers struggling for want of expressions, and sometimes you go to the vernacular and ask him, this is what you're going to say, tell me more about it. Well, a good judge will always look not for your rhetorics. In fact, rhetorics, according to me, is negative. Well, yes, a person having a good flow of language has a slight edge, but that is just an initial. That is just something initial. That's something initial edge, but that's not going to stay there. That's not going to stay. That's not going to affect your ability as a lawyer. Some of you may have very good diction, very good language, very good ability to communicate. Very good for you. But I'm now targeting those whose English is not very good, whose the language of communication is not very functional, very effective. Even they will realize after some time that what you need to tell the judge is the strength of the ideas that you have. What is a lawyer ultimately? A lawyer is a salesman of ideas. A lawyer is a salesman of ideas. You look at fact, you analyze, and then you give to the judge the idea, the point that is helpful in deciding the case. It's not rhetorics at all. There's no point in having rhetorics in court. It's not going to help you at all. Let it be very clearly told to young lawyers who have a diffidence. Generally, see, in my part of the land in Kerala, when a child talks too much, we'll say, oh, we'll make him a lawyer. You must all, those from Kerala would know that. Any child who babbers will say, oh, we'll make him a lawyer. He has all the qualities. Absolutely incorrect concept. Those who blabber are not going to make it great in court at all. The ones who have ideas, the ones who have analysis, the ones who have ability to position themselves in a good situation on the basis of the facts and the law, they are the ones who are going to make it big in the profession. Initial edge notwithstanding, I'm not saying it is not there, initial edge notwithstanding, your oratorical powers, your ability to communicate in English have just a small place, and what is more important is the strength of the arguments that you have. What do you sell? You sell your ideas, the worth of the ideas that matter, and not the ornamentation of the ideas. Yes, ornamentation gives some advantage. The salesman who comes to you gives you a very well packaged product. There is some initial fascination for that. But when you open it and sees it, if it's not good, it's not going to be accepted. And therefore, please understand that I don't want any young lawyer to be diffident thinking that, oh, my English is not very good. My communication English is not very good. I have no oratorical skills. No, that is not what is required in the profession. Yes, some advantage that may also sometimes render you. But if you have a language good enough to communicate, I think that is more than enough for you. Yeah. Well, and then there is a general impression that one-upmanship is required in court. You know what I mean by one-upmanship. The ability to think on your feet is going to be very important. That's definitely as a lawyer, that's going to be very important for you. How quickly you're able to think on your feet when you stand up. But that again is going to be, but more of thinking should take place at home when you do the homework. But even the ability to think on your legs is going to be important for you. But let me say that again. The one-upmanship is not the street smartness that we see. Well, I know quite a lot of stories go around of how lawyers respond, how they repartees, and how those carry the day. Believe me, it's not happening. It's not happening at all. I don't think one should be worried about his inability to give tips correctly at the right point of time. They are important, not that they're not important. but they're unimportant, but then that's not the most important thing at all. And therefore, young lawyers who have all these difficulties that they have, I want them to realize that these are not going to be important. It's your ability to analyze facts, your ability to put the analyzed facts into the law that is applicable, your ability to communicate that to the judge convincingly. This is what matters. And essentially, therefore, the first point is not any of these ornamentations. What is more important is your power of analysis and the worth of your ideas that matter. Well, I know another type of lawyers who do not take to litigation. No, I'll tell you that problem. Some of them think, hey, what is this? As a young student, I was a great idealist. I would not have done anything wrong. I would not have supported anyone who was doing something wrong. But as a lawyer, I have to take up the briefs of people who are there. Of course, I know it's a problem, especially on those practicing on the criminal side. Sometimes find it a problem to accept this and do this. Now, Mahatma Gandhi thought that pleading or admitting all the facts before court and then taking placing yourself in court sand would be the answer. But maybe from a practicing lawyer's point of view, I don't know how far you'll be able to do that. But I have an answer for this, because your ethical conflict when you resolve, truth is never black or white. See, truth in a given case, no case falls under the category of white or black. Most of the cases that I have handled, I find, are in the gray area, where we have to struggle to find out what is real justice, what is real truth. And therefore, when things like that come, I think your duty is to give all the benefits which the law gives to the person who has engaged you. You are not deciding on right or wrong. Your duty is to make all available advantages under the law to the one who has approached you. And truth is not unidimensional. It is not black or white. Now, your ability lies in positioning yourself to the most advantageous point for your client, taking a judge there and asking him to view facts and law from that perspective. So those who think that, oh, all these years I've been a very great idealist, I've been following Gandhi, I've been doing all these, and I've been very, very meticulously following what is just and true. And then after becoming a lawyer, for the small fee or remuneration that he pays, I have to defend the person who does not deserve my. Well, I would like you to understand that your dharma, every profession, every situation in life is a dharma. As a lawyer, your dharma is to project your client's point of view as he would want you to project. See, everyone looks at truth and justice from his angle. Your duty must be to look at things from an angle of law and facts, which is more advantageous to you on behalf of your client, and then take the judge to that point and show him that the truth and the facts and the evidence from that perspective, from that point of view. Well, if that is there, I don't think this conflict of ethical conflict would be there, provided you know your job, you know your dharma very correctly. As a lawyer, you are not deciding or adjudicating, you are only trying to point out what is most advantageous to your client, what is it. See, if he himself knew the law and if himself were lettered and knowledgeable, he would have done it. Now he cannot do it. Your duty to help him to take the court to a point where things will look attractive for him, attractive for his cause. And therefore, I would always feel that this ethical conflict would be gone if you realize the dharma that you have to perform. It is not an attempt to promote vice. It is not an attempt to promote untruth. But in a given case, there is always a position which you can take which is most advantageous and beneficial to your client. Take the court to that situation and request the court to view truth and justice facts from that angle and get whatever advantage you have to your client. Well, there could also be people who will not be satisfied with all that I say. they would think that this is all deceiving yourself. This is all trying to justify your given situation that you are in the noble profession. Well, to them, I would very, 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 very aggressively canvass to them, they are judge stuff. They are really judge stuff. Now, who think that you cannot view truth and justice through the eyes of your client, but you want to view it from a much higher sublime perspective, I would request them to kindly think of judgeship as an option. Judgeship is not one for power and position, and the judgeship also loses all its meaning. It's a great opportunity to discover truth and do justice. Now, such people who have that ethical conflict within, I would certainly advise them to do the stint as lawyers and then try to join the bench at the later points of life. I've just tried to generally to address the concerns which you are standing in front of the line. To cross the line or not cross the line is your problem. And at that point of time, I think I've by and large tried to address all the problems that in my life over the 50 years of experience, my own experience, my colleagues, my friends' experience, and in later life, what I see in the young lawyers, I've tried to generally tackle all those. Now, just one more point. The subject is to litigate or not, and where. That's one point that I want. In my life, I told you I have about 50 years of experience with the system. And I think it's a very, very invaluable asset to be in the trial court for some time. Well, trial court these days, very unfortunately, do not have that attraction at all. People are not attracted to the trial court. Everyone wants to be Shirwai or somebody in the Supreme Court only. Nobody looks at the trial court. Well, but let me assure you, the real law is being made at the trial court. The real experiments are going on in the trial court. I want young lawyers, wherever they want to go. Ultimately, you may go to the Supreme Court. I have no quarrel. If you think you are better suited for the requirements in the Supreme Court, go there and practice. But at least in the beginning of a few years, I want every young lawyer to be in the trial court. When I joined the bar, everyone used to say that without trial court experience, lawyer will be a big zero. I have in my life seen many big lawyers not having the grassroots level experience and wanting significantly on those aspects. And that is why I always tell the young lawyers. Many young lawyers with great ambition come to me now in the Supreme Court where I am practicing and say they want to join in the Supreme Court. I tell them, please spend some time in the trial court. That is where you see the legal system in operation at the grassroots level. That is an invaluable assistance in the building up of the career of a good lawyer. There are many lawyers in the High Court, judges, lawyers in the High Court and the Supreme Court, judges in the High Court and the Supreme Court who lack in this very vital requirement of grassroots level exposure. I want you to have that. Because I think my experience tells me that is an invaluable asset in the making of a good lawyer. You know how cases are born. See, I've always seen in the High Court and the Supreme Court, lawyers and judges finding fault with the lawyer at the grassroots level saying, oh, this question was not asked there, that defense was not taken up there. Little do they realize why that defense is taken, why it is not taken. See, a lawyer at the grassroots level does form the case for the people later on to work on. And therefore, it's important that young lawyers understand the pressures on a young lawyer as a grassroots level lawyer. That experience, according to me, is invaluable. And I would like everyone to spend at least a term of 2 to 3 years in the trial court, knowing how the cases are born, knowing the concerns at that grassroots level, knowing the challenges of the lawyer before that, knowing why the lawyer is taking a decision one way or the other, to take up a defense, to not to take up a defense, to take up a plea, not to take up a plea, which is very important for me. And that is where I think every lawyer must have some experience at the grassroots level. I've gone for meetings of the bar councils and the meetings organized by them. I always said that there should be a rule that the lawyer has to practice in the trial court for some time, and then only he can go to the high court, and then thereafter, after spending some time only, he can go to the Supreme Court. People rush to the Supreme Court today not having any idea about the manner in which the grassroots level functions. I call them airdrop lawyers in the Supreme Court and the High Court who do not have their feet planted in terra firma. You ought to have your feet planted in terra firma. And therefore, in order to be a good lawyer, I'm saying in order to be a good lawyer, it's very important that you understand why a certain experience at the trial court level is very, very important for you. One more reason that I would like to tell you. It's only at the grassroots level that you understand the pangs of the litigant. The real pangs of the litigant you understand only when you practice at the grassroots level. I practiced with my senior advocate K. Bhaskaran Nair in the Calicut courts. I started my career. I spent a long time, about 5 to 6 years, with my great senior. I know how really poor clients come there. I don't know how many of you in the High Court and the Supreme Court, you send your invoice, they send the money. That is it. You don't understand. You never understand the pangs or the travails of a litigant. I remember in my office there was a client who was to come from far away place and come here, and he finds the case is not over that day. He's not able to, doesn't have sufficient money for food and accommodation here. Then he comes to one of the juniors like me and would say, "Sir, I'm in great difficulty. Next time when I come, I'll give you the money. Can you spare some money for me?" Well, the pangs of a litigant, the agony of a litigant, for you to know, it's better you have interaction with the grassroots level, with that section of humanity which is really suffering. From both these angles, I think I would insist that a young lawyer must have an exposure at the trial court. Knowing how the cases are gone, what are the compulsions at that stage, why only an injunction is asked for and not a declaration of title is asked for. All your experience at the trial court level will give you very valuable lessons to understand how the system works. And also the pangs or the travails of a litigant. Now, how the delay impacts him, how the uncertainties of the law impact him, how he is not able to withstand the pressures of a long drawn-out litigation. You remember, even when I joined the bar, litigation was more or less prestige-oriented litigation. The prestige-oriented litigation. Classical example you must have studied in your thing. There was a great dispute which went up to the Privy Council, and the great dispute was the temple elephant, whether it should have the forehead mark like this or like this. This is what I call a classic example of a prestige litigation. Today, at least in my state, Kerala, I don't find people coming to court for prestige litigation at all. They are all result-oriented litigations. They have faith in the rule of law, and therefore they come to the court. Many of them come to the court because they want release. They want tangible release at the earliest. So in order to understand their concerns, what the system has to address and where the system is failing, this insight has been of great help to me, and I think young lawyers must get that. So the next question, I told you, all other avenues which are open to you are good, not bad. But then I want young idealist lawyers with enthusiasm to join the bar as litigating lawyers. I want them to join the bar at the grassroots level. Some years, don't be there endlessly. 2 to 3 years at the grassroots level, maybe 3 years in the High Court if you have, and then you have to choose. During this time, you will understand whether I am good enough to be in the trial court, whether I should go to the High Court, or whether I should go to the Supreme Court. That's your choice. That's completely your choice. But the experience at the grassroots level is, according to me, very, very vital. And therefore, I would very strongly recommend that you come to litigation with the fascination to belong to a profession, with enamored by the concept that we are fighting a civilizational war for change in accordance with law, justice in accordance with law. I have the honor and the privilege to be part of that great law army to fight this and prove to the world that this is possible. Be confident that many of the negativities which are stated in the profession can all be overcome without much difficulty. Always have the confidence that a good, hardworking, capable lawyer is never driven to penury by this profession. He succeeds. I assert that he succeeds. I have not come across a case where a determined professional has failed, has not been able to make it. Average, or he has not been able to make. Some lucky people without all these also make big. That's a different thing. Some people with all these qualities easily make big. That's also big. But the point is, you will never be disappointed provided you have the competence and the capability, as also the willingness to struggle and assert yourself. I also said that if the ethic is there, be reminded of your dharma. And if even that does not satisfy you, think of a later career as a judge where you have unhindered access to truth and justice. Of course, through law only. Even a judge decides it only through law. But you don't have necessarily got to see facts and law from the angle, from the lens of your client. You have an independent access to that. And finally, I said the trial court. I think I've done what I wanted to tell you of beginner's dilemma to litigate or not. Please litigate. Now, where do I start? We start at the trial court. Spend some time in the trial court. This is what I have to tell you. Thank you very much. You can ask me anything that you think I can clarify, or the problems that you have. Please do it. I'll be happy to do it.
Thank you so much, sir. Now we'll quickly move on to the question part. So the first question is from Amal Ehsan. Please unmute yourself and ask your question.
Hello, sir.
Yes,
am I audible?
Yes, you are. Very visible, very handsome too. Yeah.
My name is Amal Ehsan. I am from Government Law College, Calicut.
Oh, very good. That's my college. You know that. No, I'm from that college.
Yes, sir. Yeah, yes, sir. Yeah, I know. So
First batch of that college. Yeah.
Yeah, yes, sir. So I really had a question related to the financial difficulties of a lawyer. The Godfathers. The question related to Godfathers, and also the difficulties of the lawyer in the beginning. I think you have covered all the subjects in your whole lecture. So as you mentioned a question that that word to litigate or word not to litigate. I have a similar question related to that. So what to litigate? That many of the lawyers think that they have to specialize in criminal law, or some of them think that they have to specialize in civil law. Or for the beginners, I mean the first generation lawyers who are going to practice, what type of cases do they really want to take on? So what is your take on that? So that's my question.
Very, very good question by you. See, I would like to tell you that in my generation, most people have become experts in a field by chance, or by remaining in the profession for some time to see what attracts you or who you attract. Both ways is important. What attracts you is important. Who you attract is also important. You must be from Kerala, from Calicut. We had an uncrowned king of the Calicut criminal bar by name Mr. Kunjarama Menon. I don't know whether your generation. My senior was a junior to him, and so I'm also constructively his junior. He said that he started his career as a civil lawyer, and then while litigating as a civil lawyer, he slowly got attracted to the criminal side, and finally he ended up as an uncrowned king of the Kerala criminal bar. Well, if you ask me how do I decide right now, it's a very difficult question to answer. I can't tell you. I think that I'll let you leave it to you to experiment and find out what attracts you. Now, your being attracted may not be sufficient, but you must be able to instill confidence in the client requiring assistance in that domain or zone to you also. And therefore, I wouldn't give you one word answer as to where you should start, what type of litigation you must start. Yes, at a certain point of time, a lawyer is supposed to know everything, civil, criminal, labor, tax, everything. But today the law is so much advanced that it is difficult for a human being to keep abreast in all the branches of law. So you want it or not, you are going to face a situation where you will have to specialize. You know, that is why you must have heard that. You have a lawyer, so after some time you find you are not able to give services to your clients for all their requirements. So you form something like a partnership and say, civil law I look after, criminal law you look after, taxation you look after, and then together you form a partnership. Now, days are heading to that where individual practitioner covering all the fields will find it very difficult. But then if your question as to what should I see, before I joined the bar, if you ask me, should I be a civil lawyer, should I be a criminal lawyer, should I be a tax lawyer, it's a very difficult question. Nobody can answer that question to you. Now, the today's situation, what happens, unless you are sort of a very super specialist doing that branch of law, and that person will not definitely be at the trial court level, right? At that level, you will have to join the bar, be with a senior. Now you can make your choice. You know, in my time, I used to say, go to an office where there are both. Those days, a broad category of civil criminal. Now today's specialization of labor, taxation, so much of which means whichever good office that you are able to get in, you start from there. Sometimes it is by chance, sometimes it is by choice, and very difficult to answer that question as to where you should join. Find out a good senior who inspires you, and then you follow what he does. And then as you do that, you will find you will get openings to other branches. You take to it. That is all that I can tell you, right?
Thank you so much, sir. Thank you so much.
Thank you, Aman. The next question is from Senthil Kumar. So please unmute yourself and ask your question.
Hello, sir.
Yes.
Sir, what would you identify as the key professional values a practicing lawyer should hold close to heart, in your opinion?
Well, I can give you a very, very easy answer because the Bar Council has accepted it. A lawyer must be a perfect gentleman through and through. You know the axiom of the Bar Council? The Bar Council says what is expected of the most important axiom of professional conduct is you must be a gentleman. Gentleman including the female dimension of it. But then many things which are okay for the others is not okay for a member of the noble profession of law. And that is why it has not been very strictly defined. And it has been said that all that is expected of a gentleman, all those qualities you must possess. Well, coming to brass tacks, if you ask me, I think sincerity to your client is a very important dimension. Well, that's very, very important. Your competence in law is very, very important. Your willingness to uphold professional etiquette and principles is very, very, very important. Your duty to the court which you recognize, which you should understand, is also very, very important. Now, all these are very too general. I know you will say me, what is this Basant are telling me? He has given me a very vague thing to say that I must be a gentleman. Well, that is it. The profession to which you aspire to belong is a profession where you cannot see crib and cage. It transcends all the slots that you have to say that you must be a perfect gentleman. It includes your duty to your client, duty to your brother lawyer, duty to your juniors, duty to your seniors, duty to the court, and duty to society at large. And therefore, if you ask me what is that one quality, well, if I may say so, I would tell you, you must be a competent lawyer dedicated to your client's cause. In the right sense. You have learned it by now in your law college. You're not a simple agent of the client, you're an enlightened agent of the client. You have a duty to direct the client to act properly too. When I say dedication to the client, it's not a mercenary dedication. And that's not what I'm thinking of. It's not a mercenary dedication that I'm talking about. It's a dedication of an enlightened agent to his principle. And I know you have not perhaps got the answer that you're wanting from me, but it's very difficult to give you one word answer to that. Thank you.
Thank you, Senthil Kumar sir. The next question is from Saji Kumar sir. Please unmute yourself and ask your question, sir.
Good evening, sir.
Good evening.
Sir, I am really privileged to be here. I am currently working as an assistant professor in Government Law College, Calicut, sir.
Oh, really? My God, my college. Very good. Tell me.
Sir,
You must encourage young people. You must
and
inspire them to join the bar. You have a great responsibility in doing that.
yes, I take questions. What is the role of a law teacher in regards, sir? Moderate young friends. I am really, because one of my students had a very genuine question with you. That's why I interfered.
I didn't get you. Tell me what. Repeat that. I didn't get you. One of your students?
Sir, what is the role of law teacher in this regard, sir?
Well, law teacher is the...
And I'm proud because one of my students, Amal, previously asked a question to you, sir.
The first wife.
He was presently a student of our age.
Okay. Very good. What is the role of a law teacher? Very good. Very good question that has been put. The law teacher has a great role not only in developing the law, but also in molding your students, right? Because you know that the concept of prospective overruling came from a university. You know that, isn't it? Golaknath case, when it came, the concept of prospective overruling came not solely from the bar, but it actually emanated from a university. So I'm not on the academic perspective of it. Your question was, how do I deal with my students? Well, you must always give your students the ideal of a noble profession, a learned profession, and their duty to join in history's experiment, civilizational experiment of justice in accordance with law. Justice, social, political, and economic through law. So that is the Indian law experiment today. If it does not succeed, you and I and all of us will be found guilty at the bar of history. We have not done our part well, and that is why the experiment did not succeed. The founding fathers had great dreams about this concept, but then we could not work it. That is. So your very, very, very conscientious question, what do I do for it? You inspire your students to be part of this great civilizational experiment that is taking place in India now, and tell them that their commitment that ought to be there for the less fortunate. Well, that is. See, do not always give them the examples of. See, I know. See, my son is a lawyer. Now, I compelled him to join the local bar first, do 2 years here, and then only move out to this. No, because I know the importance of that. And you must also inspire your students to take to law. They have a lot of diffidence. They have a lot of diffidence in joining the bar. And therefore, I think primarily you can inspire them by the idealism of the legal profession. Idealism of the legal profession in our given context. That is where you can help them really.
Okay, sir. Thank you.
Thank you.
Thank you, Saji sir. The next question is from Unimaya. Please unmute yourself and ask your question.
Am I audible?
Yes, you are.
Sir, my name is Maya, and I'm from Law College, Calicut itself. So it's a privilege to meet you like this. And my question is, what would you suggest to a person who has an artistic mind who has been thrusted into this profession? I mean, like they came into this profession by accident, kind of. So they're having this conflict whether to choose the artist's way of thinking or the lawyer's logical wise thinking. So is there something you'd suggest like that?
You look very much an artist, I can say that. No, I really see your point, because law is logical. It is artistic too. Law is neither a pure science nor a pure art. You know that, isn't it? It's neither art nor science. It's a combination of both. As a judge, as a lawyer, as a judge, when you try to put across points of view, you ought to have artistic imagination sometimes, and then try to put it in the confines of law. So you need an artist in every lawyer. You need people having the ability to imaginatively foresee things. I always felt that MT would have made a great lawyer. You have seen it, you know. In many of the, when he portrayed Chandu from his point of view, that's what I a little earlier wanted to tell you. See, the ability of a lawyer is not, it lies in taking the court to a point which is most advantageous to your client, and viewed from that angle, you would look justified. Even though from many other angles you may look not justified, right? It's a perception, and that is why I said, you know, the dharma of a lawyer is to take to view truth and justice from a point of view which is the most advantageous point of view for your client, and try to sell it to the judge from that point of view, right? And therefore, your question as to whether a lawyer should be of a scientific temperament or an artistic temperament, or whether a person with an artistic temperament can fit into the scheme of things, I would certainly think easily yes. My answer easily is yes. You need it. Not only that you can do it, you need it. Many a time you need it. Now, sometimes I used to tell my friends, he is the greatest criminal lawyer who is able to put across his client's case as if it is a story. Right? It depends on where to stress, what not to stress, you know, and therefore there's a lot of artistry involved in even a very ordinary, mundane legal argument. And therefore, you artists, please don't think that you are out of place in the scheme of things. You are very much in place, and then you can do that. Okay. Have I satisfied your question?
I guess that answers your question, Unimaya. So the next question is from Anu AS. She has an audio issue at her end, so I'll be asking her question. Her question is, what about the gender equality in our profession?
Oh, very, very, very wonderful question. A very, 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 very effective question. I can see that question coming up every now and then here. Well, we have always thought the general idea has been law is a very jealous mistress. The profession of law is a very jealous mistress. Even that femininity is given, and it's always assumed the man is the one and the mistress is one. It's true. It's true. Given today's world, the woman has a lot of professional commitments, more than a man. It should not be there. It should not be there. I might readily agree with you. All the responsibilities of the household must be shared by both, and therefore there's nothing wrong. I'm sure my wife is not around. She will say that all this you're saying, but you're not following it. You know? But the point is, in today's world, there is no artificial distinction between a man's jobs and a woman's job. It's all to be shared. If that be there, and if you really follow that, people like me may not be following that, as I said, but if you really follow that, I don't think there should be a gender inequality at all in the profession. Now, if you come to the Supreme Court today also, you will find quite a number of young women doing mighty well, outstandingly well in the profession. They are leaders who are ushering in this change. The change is coming in. Now, for the Kerala judicial system, you find they are slowly outnumbering men in the judicial profession. They are slowly getting to that, and therefore, yes, if you today now one way of how some women work out gender justices. Today there are only 3 judges, the Supreme Court lady judges, and all the others are men, and therefore there is no gender justice. No, I don't think that. I think that will be a small way of looking at it. It's not as though everything must be 50-50 or 1/3, 2/3. What is the total number of women in the profession, and what is the number of women who are stuck to the profession? And that statistics may have to be taken to decide whether system is gender biased. Well, I think there has been a bias. There has been a bias. I know. I'm not trying to run away from that. This has been reckoned as a male bastion preserved for men alone for various reasons. But those reasons are slowly vanishing. And then gender justice is coming in more and more. If you look at it, well, a woman has a lot more of challenges today, as it today is. She has a lot more of challenges because most of the men do not share the home responsibilities, and therefore it's a heavy burden on her. Now, to ask a lady junior with commitments, it's okay with an unmarried young lady, there's no difference. But for a woman with a lot of commitments, to request her to remain in office beyond, say, 10 o'clock would be very difficult. Our world being what it is today. And therefore, we are working out justice. The gender justice does not work out on one fine morning and say all is fine. That doesn't happen. But we are moving towards a more meaningful gender justice profession as it is today. And I don't think, there are many, see, as I told you, macro impression is not required to be a good lawyer. It's your power of analysis, the strength of your reason that ultimately carry the day for you. And women are doing mighty well in that front. And therefore, there should be no problem. Gender justice, not as much as we would like to have it today, but we are definitely on the road to that.
I hope that answers your question, Anu. The next question is from Anne. I'll be reading out her question as well. What are some of the key qualities a law student must develop while in law school to enter into litigation? Or how can one prepare into litigation during law school days?
Most of you have court work these days, isn't it? What do you call the court diaries? You have to attend a specific number of court work, isn't it? I think that's a part of the system now. You have to do court work. You have to do chamber work. Now, see for yourself what's happening in the court. See, I would think that how you prepare yourself for the responsibilities of litigation in future is, see for yourself what is going on in court. Imagine yourself in the position of an arguing counsel and assess for yourself whether you'll do well in that or not, and what all qualities you must have. I think the power of analysis of the facts and law will be very important. Ability to put across stand your ground and put across your point of view is another. These are qualities like boys you have to develop as days go by. Reading would help you a lot. Reading judgments and even legal fiction would help you a lot.
I guess that answers you, Anne. So next question we have from Mrs. Geeta Menon. Ma'am, please unmute yourself and ask your question.
Sir, good evening. Can you hear me?
I can hear you. Yeah, I can hear
you. Sir, I have just meant to discuss with you about something which was also a concern to me. I was interested in law from a very beginning, but at that time when I was supposed to take law, I couldn't do that. Now I'm 65 years old, but I still want to study law. I'm doing it now. I've completed 1 year. I'm just asking, what is the advice that you can give me for my profession to take this as a new career now?
What were you doing hitherto, Geeta?
I was doing banking. I was in HSBC Bank before.
Okay. It's never too late to be in the profession. You don't have to feel diffident on that score, because life's experience matters a lot. You have that great advantage to you now, right? You have a great advantage. Life's experience matters. You are very, very wealthy now. Maybe you have not done the but many of the problems for a young entrant is not there for you. because you are evidently reached a stage where you know fully well that you are not going into aggressive practice that way.
Yes.
Unlike young children, you don't have to make a living out of it, and you have very little to prove more now, isn't it? Young
Correct.
people have all those problems. You know, when I after my stint as a judge at the age of 62, when I decided to go to the Supreme Court and set up practice, I keep telling everyone, my single point agenda is that I must be enjoyably occupied. I'm not here for an aggressive practice. There is no aggression. There is no competition. I must be happy. Well, that is what concerns you also. I had I was a judge, and therefore I had continued to have the legal exposure. You did not have strictly legal exposure, but as a bank person, you must have come across quite a lot of legal problems also. And therefore, I don't think you should really worry about this, because you have a state of mind which is much more advantageous to the legal profession than a new young entrant. And therefore, you don't have to worry about that at all. You're having walked a little longer in life. That need not worry you at all. Well, I would always want you to have a realistic acceptance, but the young entrant is about 50 years ahead of him. We may not have that much we need not plan for that sort of a career. What are you trying to do? You did not do certain things which would have given you happiness at earlier points. You were not able to do that. Now you're trying to do that. You want to be enjoyably occupied during the remaining part of your career, isn't it? That's your primary concern. And I'm sure, given this, if you can think of joining law after your retirement in bank, I'm sure you will do well. I have no doubt about it.
Okay.
Yeah, the attitude that matters, and you have that attitude, I can see from the very fact that you have joined the college now after so many years and really wanting to do law, to litigate and practice. All the best to you. I'm sure you don't have to worry about anything, because
actually, my view is to take law to the grassroots level. People learn and know what is law from beginning, so that they don't end up in a crime. What do you say about that?
Yeah, well, that is an attitude with a social commitment. Yeah, as you know, perhaps I'll just digress and say the Anglo-Saxon system of laws is founded on one fiction. We call it a fiction because it's not real always. What is that fiction? That all people, all citizens know the law, right? It's a fiction. It's never true. It's never true even of judges and lawyers also. Who knows the law? And therefore, the success of a system depends upon the closeness of the fiction and reality, right? You understand that? This is a fiction. The fiction is all people know the law, but factually, people do not know the law. Many people do not know the law. The system to be effective, the gap between the fiction and the reality must be as narrow as possible, tending to zero. But that's not the situation in our country today.
True.
Therefore, there's a lot of room for people like you with a commitment to take law to the grassroots, that you yourself put it. You have a lot of function to perform, role to play, reducing the distance between the fiction and the reality. And that's what it is. You can do that. With your knowledge of law, you can do that also.
I have a suggestion in that case, sir.
Please do that.
Can you join hands with me to start that?
Me? Okay, let us see.
I think as you put in, money is not a factor at this age, right?
No. As I told you, no, it's not a factor at all. Yes.
So if we can put the two brains together, I think we can do something for the nation.
Let's see how we can do that. Let's see. Okay.
Okay, please share your contact details so that
you take it from Niranjana, she'll give you. Okay.
Yes, thank you so much. That was really good.
Thank you very much.
You have given a breathing space to me today.
Good. You have a lot of breathing space. Only you have to realize that is all. I did not give you. You should realize that is all. Very good. Thank you very much.
No, as you put in, people might ask me, why are you doing law now? But I don't know why I felt like doing it. I said I have to do it, but now I feel that I must do it, and I've got a good backing. That's what.
No, you see, even that is incorrect. See, studying of law is not to practice alone. Look at it that way also. Studying of law is not to, every citizen is bound to know the law. You're not been able to do that so far. You're trying to do it now. Look at it simply that from that point of view, not from joining the profession as such, which you should join the profession now. But I'm saying there is no question ever possible as to why are you doing the law now. Till the last breath goes out of me, I should know the law, and therefore I should learn the law. No problem with that.
Right. Thank you so much, Basant sir. I'll keep in touch.
Do it.
Thank you.
Thank you, ma'am. The next question is from Amal J. Lal. I'll be asking his question. Advocates on record system implementation on High Court and how it will affect young lawyers who is just in beginning of his or her career.
You are dragging me to a very controversial subject. I know that, because see, you should know what the advocate on record system is. First of all, one should know what the advocate on record system is and what is the purpose of the system. It is not to create a closed shop arrangement where some people alone can file cases. You should understand that. There's a general misreading of the provisions of the provisions relating to the advocate and record system to think that it gives monopoly for some lawyers to file cases, and that is the purpose of the system. It is not. The purpose of the system is to ensure a certain amount of discipline in the filing of cases. Right? And therefore, in the Supreme Court, only persons who have been recognized as advocates on record are permitted to file it. Thereby, the Supreme Court insists and ensures that the procedural formalities are complied with properly. It is not to give any edge or advantage to people in a certain place. And therefore, I really do not know how much advocate on record system is necessary to be extended to other places, but the system has not been there at all. Well, there are certain other concerns which are prompting people now to introduce the advocates on record system, but I don't think it is essential. Left to me personally, I would think that there was nothing wrong in the system working perhaps in the Kerala High Court, where all lawyers could file it. Now, Supreme Court is a peculiar history behind it, practice behind it, and that's why there are advocates on record. I don't think there is any need. People may be able to file it from Kasaragod, from whichever corner of the country, will be able to do e-filing. When the e-filing comes, some people may think that it is the monopoly is lost, and that is why. And young lawyers, how it would affect young lawyers is if the system comes, only advocates on record will be able to file it. Whereas today, even the junior-most lawyer can file the case. Now that would be how it would impact it. Well, it's a big controversy going on now whether they ought to introduce the advocate on record system or not in the Kerala High Court and in some other high courts. I think it's all an offshoot of the possibility of e-filing cases from whichever location you are. And therefore, if advocate on record system is insisted, then you can the people nearer to the court have the monopoly of filing it. That's all.
I hope that answers you, Amal. He has mentioned. Thank you, sir. So the next question is from Saurav. I will be asking his question again. What will be the approximate time for a newly graduate law student to be established as an independent lawyer?
Very, very interesting questions of concern to you, but to give a timeline would be difficult. I would certainly say to give a timeline would be difficult. I've seen young lawyers passing out from the college, and till the bar exam was there, straight away walking to the court and doing practice. Well, it varies from person to person, but on an overall thing, I would think 2 to 3 years with a senior would put you in the groove, and you'll be able to pick up work on your own. How much work you pick up, how much time would be required to establish yourself, this varies. In individual cases, it would vary. But 2 to 3 years, I think you can certainly think of establishing your own office.
Okay, that answers Saurav, I guess. So the next question is from Anjana Jairaj.
Yeah.
Please unmute yourself and ask your question. I'll ask you her question. Her question is whether doing an LLM is necessary for entering into litigation.
Not necessary at all. Not necessary at all. Doing an LLM does not give you any tangible advantage over the others from the point of view of practice. It only widens your scope. It only widens your perception of law and the academics of law. And I don't think doing an LLM is any way directly related to your setting up practice or even your success in the profession. I don't think it. Maybe certain specialities are there where you might attract more work if you have the specialization. That's all. That's all.
The next question is from Arshad Khan. Please unmute yourself and ask your question.
They are not unmuting themselves.
I think that's the problem. Yeah.
Okay, then I'll ask his question.
Yeah.
So what is your take on shifting of courts to online mode, especially the advantages of techno-savvy youngsters?
Well, the immediate provocation for online courts is the pandemic, right? Immediate provocation is that. But maybe a time would come when we would prefer to have online courts. At least some portion of it, certainly. And it would be advantageous. It would be advantageous to the lawyers, to the courts, because see, a lot of improvement in the technological infrastructure is required. Today you have a lot of problems. You don't get connected. You see the judge. Sometimes you do not see the judge. Sometimes the judge sees you. Sometimes the judge does not see you. Sometimes he hears you. Sometimes he's not able to hear you. This problem is going on. Those are all inadequacies of the technological infrastructure that we have. But once it is perfect, and I think that it is definitely going to be the in thing tomorrow. Whether you like it or not, your liking is irrelevant. Many of us may not like, old people find it very difficult to adjust to new things. No? And therefore, you see, the young people will steal a march over us. You see, I would like somebody to sit near me to get everything right in place. So you can see that happening with the senior lawyers also in the Supreme Court also now. You need somebody that the tech-savvy youngsters will certainly have an advantage over the others in that, but that is bound to happen. That is bound to happen. This is inevitable. March of time, you will have to learn it. Now, those who want to remain in the profession will have to get used and get acclimatized to the changing scenario. Those who are not able to do so will be thrown to the dustbins of history. You are not going to succeed without. These will be the inevitable minimum qualification that will be required for all. E-filing once introduced, everyone will do that. That will save a lot of time. A lot of evil practices can also be put down by that. And therefore, we are not going to avoid e-filing at any point of time. And once e-filing is there, we'll all have to get competence for that. If those who do not have competence will not be able to do that. And tech-savvy youngsters will steal a march over them, definitely. But then, after all, these are not such complicated systems that one cannot do that. Or I would think that the technically qualified personnel will find employment in all the advocates' offices also. So it's not going to really affect your practice. It's only adding one dimension either to yourself or to your office. Well, and therefore, yes, tech-savvy young people will have an advantage. There's no doubt about it. Does not mean that the others will have a disadvantage. You can always borrow it. You can always borrow it. I can always have a tech-savvy person sitting by my side to help me do all that. And so therefore, that's not going to be a concern at all. That is no arguments in favor of or against an online existence, online performance.
We'll move on to the next question. The next question is from Nabamita Karmakar. Please unmute yourself and ask your question, ma'am.
Good evening, sir.
Good evening.
Hello.
Please, I can hear you. I can hear you.
Good evening, sir. This is Navamita Karmakar from Law Department, Bardhaman University, West Bengal. So I have a very silly question, sir. What is the difference between a lawyer and an advocate? This has haunted me a lot, but I'm yet to get a very convincing answer.
Lawyer is one qualified in law, right? Advocate,
Okay.
I believe basically there is no difference when you call him a lawyer or an advocate. Advocate word, the semantics you'll understand. You vocate the cause of another. You give voice to the others. One who is giving voice to another is an advocate. So that is what the Indian lawyer is doing. There is a lot of voiceless people around you who have all the rights, whose voices deserve to be heard. Right? You are giving voice to them. One dimension of it, your work is you are vocating the cause of the others. And then you are a lawyer because you're qualified in law, then only you can do it. Well, so the word meaning lawyer and advocate, I don't find any difference. You can call yourself an advocate or a lawyer, but function-wise, you're giving voice to the voiceless. People who are not able to make themselves heard in courts, you are giving them voice. They can also come to court and argue their matters, isn't it? You know the law. The law is that anyone can come to court and argue his own case, but he has no voice, he has no language to communicate to the court, and therefore he needs the assistance of a lawyer, and that lawyer gives him voice, and therefore he is a lawyer advocate. Right? I don't think there's any difference between them. The question is not silly, but many of us have not adverted to that question. Really. I don't think there's any difference between them.
Okay, thank you so much, sir.
Thank you, Nabamita. The next question is from Jayan Walapul. Please unmute yourself and ask your question, sir.
Hello.
Yeah, yes, please.
Hello. Am I audible, sir?
Very, very.
Yeah. Good evening, sir. I'm a law student from Calicut Government College.
Calicut, huh? Oh,
Hello. Yeah,
okay,
Calicut.
my college. I have a weakness for that college. Yeah.
Okay. First of all, thank you very much. Your lecture is very informative and motivated me. And you speak very well that the communication skill and presentation, everything is very fine. And my question is, why did some of the lawyers drop out in the early field in the beginning time? And also, what is the message for the beginners or the new lawyers to stick on the lawyer field when also the COVID and the financial earnings capacity like that?
Yeah, I understand the question. Why do people drop out? It is a very fundamental question that you have posed. Why do people drop out? I believe a person fully committed will never drop out. Well, if a person is fully committed, temporary adversities is not going to deter him. He may not. Sometimes what happens is you by chance you join the bar, you realize that you do not want to do it. He drops out. Now that also you can't say anything. Sometimes actual experience at the bar sometimes tells you, oh, this is not my cup of tea. I don't want to do it. Now standing outside, you may not have been able to perceive it. I know many judges of the High Court who joined as judges, spent some time there, and thereafter found, oh no, this is not my cup of tea. I don't want to continue in this. He resigns and goes away. Now, this is nothing to do with this. Is all personal choice. No, but the question that you are posing is because of financial difficulties, some people are able to. Some very competent persons who want to do law. I know. I remember when I went to the Koilon Bar Association one time, a police officer who was there, he came and told me, "Sir, I was a lawyer too. I really wanted to do law, but the pressures were such. My family was so poor. I could not stick on to it after 3 years. I was forced to give up. That is a problem. That is a problem. That is what the system provide for. The senior lawyers, for example, have to make sure that the juniors are well looked after for some period of time. That's why when in my address, I told you, if chartered accountants can insist that their apprentices must be paid a certain amount of money every month, I really do not understand why the lawyers cannot be compelled to pay subsistence remuneration to their juniors. I can also see the Bar Council must also take up the responsibility and ensure that sometimes the juniors are not able to. See, what happens is if you insist on this law, seniors will not take up juniors because that will be a monetary commitment to them. Like the chartered accountants, those who are having 10 years of practice must have 2 apprentices. Similar rules can be brought up here also. They should not be so difficult. And therefore, the Bar Council, as an organized body of the profession, and the individual senior lawyers as members of this noble profession of law in a more advantageous position, must be able to look after their juniors, not endlessly. So at least first 3 years, he must be helped, and thereafter he may have to stand on his own legs. We can't help him thereafter. Thereafter, it's a do or die for him. He has to fend for himself. But people should not be deterred during the first 3 or 4 years, whatever time you fix. That can be insisted by from the seniors and Bar Council. That can be done, and so that this dropping out because of financial reasons, financial instability can be avoided.
Okay. Thank you very much, sir. Thank you so much.
Sir, we have 2 more questions and we have already exceeded time, but is it okay for you if we continue with it, or?
2 more questions doesn't matter, do it.
2 more questions and we'll wind up. So the next question is from R. Vivekan. Sir, please unmute yourself and ask a question.
Sir, good evening. My name is Vivekan. I practice at City Civil Court, Hyderabad.
I see.
My question is based on the recent controversial on Prashant Bhushan. Since you are also practicing advocate at Supreme Court, so based on the recent controversies that Prashant Bhushan has...
A matter pending before the Supreme Court. Supreme Court has already heard the matter. They reserved orders on that. I'm not going to say anything on the specifics of Mr. Prashant Bhushan's proceeding against Mr. Prashant Bhushan.
Well, that's not my question.
But I do always feel that the shoulders of the court must be broad enough to take criticism.
Well, I haven't completed my question.
Yeah. Please, I'm sorry. I shot into it. Please do it.
Well, the question is...
I could anticipate the question, and that's why I say it, because if you want me to comment on the specific controversy, I'm not going to do it at all, because the matter pending before the Supreme Court...
I just wanted your views on the Prashant Bhushan case when his statements were more than 50% of the existing judges are corrupted, and retired judges of the existing the legal fraternity have already confessed that yes, Prashant Bhushan is correct. And I want you and your perspective, how do you project it in case you are representing Mr. Prashant Bhushan? That's my question.
I'm not representing him. I'm not going to...
I understand that. In case.
And therefore, I'm not going to comment on that question of you on merits of what has happened in this particular case. I would broadly say, no, it's not for somebody else to admit that the judiciary has been corrupt also. Maybe we have not lived up to the expectations very correct. But to say that use the word corrupt may not be in good taste, but if the judiciary has been corrupt, I believe people should have the right to criticize. And they do have the right even now. As you know, the truth is a justification in certain areas now. But general sweeping remarks are in bad taste when you think of an institution as such. I'll just say that and be done with it. The judiciary is also not immune from criticism. We must be able to take criticism. The shoulders of the judiciary must be broad enough to take criticism. I would also at the same time insist that indisciplined, irresponsible criticism will also have to be avoided. Let's stop it there. I don't propose to answer anything.
That answers my question. Thank you.
Thank you, Vivekan sir. The next question, I'll read out the next question, sir. Whether CBI persons are LLB qualified, as he has a much logical questions.
Well, it's not a rule of law now that the CBI officers have to have legal qualification. As far as I know, there's no insistence on that. Once they are selected, they have to go through the law subjects, courses in law subjects also. And certainly knowledge of law is essential for a police officer. More so for a police officer at higher levels performing more sublime functions. Right? And therefore the qualification in law would be very, very advantageous for a police officer. But it is not the law yet that he must be a law graduate, whether you are in the local police or in the CBI. But I agree with the one who put that question. May not be full lawyers or law qualified persons. They must be put through very rigorous training in law while they are being trained as police officers.
Thank you. With that, we have come into the questions session of this whole class. On behalf of everyone who is attending the class, in behalf of the whole team of Outspoken Narrative, I thank you, sir, for giving us this opportunity to host you. And thank you so much for taking out time from your very busy schedule for us. It means a lot for us young students. All of us in the Outspoken Narrative are law students, and for us, it means a lot to get this opportunity to host you. Thank you so much, sir, for this chance. And I'm talking on behalf of all those who have attended. I'm pretty sure everyone is leaving this webinar having their queries answered in every and being motivated and from your words of wisdom. Thank you so much, sir, for this opportunity that you have given us.
Thank you very much. I also enjoyed it. Very, very bright minds are putting questions. I really enjoyed it. Thank you very much.
I'm glad you enjoyed, sir. And thank you all the participants.
Someone there is showing his hand, Jan Walapal. No, I can see him showing his hands, you know. You want to say something? Who's that?
Jen.
Probably is wanting to tell you something. I don't know what it is.
No, nothing, sir. Thank you very much so much.
Okay.
Thank you very much.
Oh, you are the one. I thought it was somebody who didn't speak.
Okay.
Okay. Thank you very much. Thank you all. I've enjoyed. I really enjoyed. Thank you.
And thank you everyone for attending our webinar. This is our 6th webinar, and it means a lot that we still have such a huge support from everyone. So thank you. We will be uploading this recording on YouTube on our channel. If at all, if we want to revisit the entire session, we can always go back to our channel and watch it. Thank you so much.